Welcome back to Law and Crime Live. My name is Stephanie L. Willis, and I will be with you for the remainder of the afternoon. We are still covering Ohio versus Shawn Michael Grate. We pulled away from the courtroom just a little bit as testimony is still proceeding. However, we did notice that the audio was a little bit poor. But what we have our wonderful guest. We have Gary Gerstenfield here with us this afternoon, and he's going to provide us with some great legal analysis. So, Gary, thank you so much for being with us this afternoon. We do know that earlier we had some testimony from Captain Lay, and we had some testimony from Detective Kim Major, who we know interviewed Shawn Michael Grate. We do know that she first interviewed Jane Doe, and she received a lot of great information from Jane Doe. And after interviewing Jane Doe and sending her to the hospital, she then interviewed the defendant, who provided her then with a statement where he talked about killing the victims and the rape of Jane Doe, when previously he admitted to the rape of Jane Doe but denied the killings. Tell us, as a defense attorney, how does that work in your favor?
You mean in the favor of trying to come up with a defense where you
Correct.
make an admission or confession and
Yes.
then recant later?
Yes.
Well, so when you make a statement to the police, before you can make the statement, or at least before the statement can be admitted, if you're the target of a criminal investigation, meaning that you're in a position where you're not reasonably free to leave, you have to be advised of what's known as your Miranda rights. And the Miranda rights basically are to make sure that the defendant understands that, A, he doesn't have to talk to the police if he chooses not to, and B, that he has the right to have an attorney, and C, most importantly, that if he says anything he says can and will be used against him if it can be. Oftentimes, and this is an example where you have an individual who is, in a way, proud of what he's been doing, and he wants to talk about it. But he also knows that if he talks about it, he knows he's going to get himself in trouble. So he's somewhat conflicted. On the one hand, he wants to brag about his activities, his crimes, and on the other hand, he's mindful of the fact that by making any admissions, he's potentially putting himself in jail. And that conflict, you can see, is borne out when he's being interviewed and he makes statements and then later he recants those statements. And the question is, does recanting the statement somehow nullify the admissive statement? No, it doesn't. And then it's up to the trier of fact to decide how much value to give to the admissions.
Okay. Well, what we're going to do now is we're going to actually take it to a clip of the BCI Special Agent David Hammond. So we're going to take a look at that clip, and then we'll come back and discuss this with Gary when we get back. Welcome back to Law and Crime. What you just see, we do have Detective Kim Majors still on air, not on air, on the witness stand at this time. But I did want to discuss with Gary a little bit some of the problems that we may have when we have individuals who are collecting DNA evidence on behalf of the state. We just heard testimony from David Hammond, who is a BCI special agent in the case of Ohio versus Shawn Michael Grate. So, Gary, why don't you tell us or talk to us a little bit about some of the problems that can occur when we're dealing with multiple or swabbing multiple areas for DNA?
Sure. So we were just listening to the technician testifying about him taking a DNA swab. The way they're supposed to do it is they have a prepackaged envelope, and in the envelope are all the things they're supposed to be using for a DNA detection. And the whole point of that is that the DNA profile they want to develop, they need to show chain of custody that the DNA, I'll touch on that in a moment, but they need to show that the source of the DNA is accurate and that the DNA belongs to a specific individual. So, for example, in the case of Mr. Grate, they took DNA from the left hand, several fingers, and then from the right hand, several fingers, using separate swabs, and then they used a special swab or a specific swab to swab his penis. Nothing wrong in that situation.
Right.
But what happens if they use the same swab, for example, for all three areas?
Right.
They would definitely potentially get a DNA profile. However, the significance of it may be very different. So, for example, as the detective was talking about, high-fiving somebody is not sexual contact, and yet you can still capture a DNA profile and show that there was contact. versus a DNA swab taken from someone's penis or from someone's genitalia,
right,
or from an area that isn't generally exposed, that would suggest a sexual contact. And so from technicians' point of view, they need to be mindful of not contaminating the swab with, and when I say contaminating, going to multiple sources or potential sources to obtain DNA material and leading to potential confusion as to what that DNA profile actually means in terms of whether it's sexual contact or just social contact.
Right, because essentially if that did happen, that would be a field day for a criminal defense attorney, am I correct?
Absolutely.
Right.
And again, what I talked about was maintaining, and another aspect about DNA profiles is you have to maintain an absolute strict chain of custody.
Right.
And the reason why is because DNA, our DNA cells are strewn throughout the earth. I mean, anytime you have contact at the grocery store, 7-Eleven, any place you go, you put your hand down, you're potentially dropping off cells that could lead to somebody suggesting that you had some sort of contact. DNA never tells you when, it only tells you where.
Right.
And so one of the issues is always you have to, time and place means a lot, and that's the whole part of what we call chain of custody. That means that from the technician gathering the evidence, gathering what may be DNA, and then examining that DNA, and then developing what we call a profile, which is unique to each individual, and then being able to present that in trial, you have to be able to show that that DNA profile is from a specific source, it's important, a specific time, and that there's no risk of contamination, what we sometimes call as a slurry, where you're developing a DNA profile from multiple sources, and you end up with a confusing DNA profile, and it's hard sometimes to distinguish whose DNA you're actually looking at.
Right. Well, I mean, great explanation from Gary to kind of break down how important it is, one, finding DNA evidence when the state finds DNA evidence, but also in the way that they handle the evidence that is found and how they ultimately test the evidence as well. So I think that was a great breakdown that you provided us with, and actually something that I think is quite important to this case, even though we do know that there was a confession to these murders. And so we have Shawn Michael Grate here, and we're going to talk about this a little bit more. I do want to get into this a little bit more with you, Gary, if I may. Just having these confessions. 1 minute he's saying that he did not kill anybody. The next minute he's saying that he did. The fact that we do have conflicting testimony from the actual defendant, what do you think that that does for the state? Does it bolster their case at all, or does it make it a little bit more difficult for them?
In the end, I think it bolsters the case.
Okay.
The whole point of this is, okay, what is a confession? If I were to confess to killing John F. Kennedy, I was born in 1962, I would have been 1 year old. Obviously, that confession would make no sense.
Right.
A confession needs to have detail to have significance. We don't want people simply going up and confessing to crimes for the notoriety, to make themselves famous. The confession has to have detail to it. It's more than just, I did it. How did you do it? Where did you do it? When did you do it? These are the details that are part of a confession. Think of a confession as just a statement or an admission. Okay, and think of it as a conversation. And so when we refer to something, when we say the defendant confessed, what we're saying is that the defendant, the person accused of the crime, sat down with a police officer who's trained to get statements from the defendant and entered into a conversation. The conversation includes statements that are awesome to prove his participation in the specific crime, whatever that crime may obviously be. So it's not that I simply admit to doing the crime. It's I admit to doing X, Y, and Z collectively, showing that I participated in this crime.
So you're
and then
essentially
coming
saying,
back later and saying, well,
I just want to break it down for our viewers just a little bit, because I think that you're doing a great job breaking the actual importance of a confession down. It's the fact that you have to say, yes, I did it, but provide all of these details in order for it to pretty much work. Am I correct?
Yeah, I think a jury would be very, particularly today with false confessions
right.
and, we've seen people who've spent decades in prison based on a false confession and DNA evidence with the Innocence Project, which has done a fantastic job. And more than 250 people now have been freed from crimes they were convicted of, many of those crimes involving confessions. So people are mindful. I think it's part of the popular lexicon. It's part of our culture to understand that sometimes people confess to crimes that they didn't commit for all kinds of bizarre reasons. So we look at the confession, we need to see detail. We need to see information that would be unique that only a person who committed the crime would know. It's more than just, yeah, you're right, I did it. What did you do? When did you do it? How did you do it? And then coming back later and saying, well, no, I didn't do it. I just made that up. That doesn't hurt the case, because changing your mind later and saying, well, gee, I don't want to say that I did this, it doesn't mean a whole lot, particularly in the case of someone like Mr. Grate, who I honestly genuinely believe is proud of what he did. Proud of it. He wants to brag about it. It's how he defines himself. It's his own personal large id of who he is. He's a serial killer. He's proud of that, and he's tortured people. He's proud of that. He did it with great relish, and he wants to brag about it. That's the one side. The other side of him says, well, you know, if I keep talking about this stuff, I guess I'm kind of confessing to a crime, and that could put me in trouble. So he's sort of balancing in his own mind, or battling in his own mind, his desire to brag about what he did to anybody who will listen, while at the same time aware that by doing that, he's also getting himself in trouble.
Yeah, well, I have to agree with you right there. Thanks so much for breaking it down for us, Gary. What we're going to do is we're going to continue providing you with some clips from testimony from the actual Jane Doe victim, or the alleged victim, I should say. What we're going to do is we're going to play this clip, and then we're going to come back and break it down with Gary. Stay tuned. Welcome back. What you heard was some really hard testimony to listen to from the alleged victim, Jane Doe. She was describing everything that happened prior to her actually being able to leave the home where Shawn Grate actually kept her. We still have Gary Gerstenfield on the line with on air with us today. Gary, thanks so much for being here with us again. And I know that you were listening on into Jane Doe's testimony. This was really kind of hard for us here at the Law&Crime Network to listen to. So I can only imagine for individuals such as the jurors who don't, they don't listen to this kind of thing very frequently, we would assume. So as yourself, as a defense attorney, what is your tactic when approaching this this alleged victim during cross-examination? I know, it's a rough one. Well,
so the first thing whenever you're listening to a witness give testimony is the testimony accurate information? After all, the whole point of a trial from the prosecutor's standpoint is they have to prove their case. They prove their case by producing evidence. Evidence can be written documents, it could be a video recording, or it can be live testimony. And so, like any other piece of evidence, anytime a person talks or tells you something, you can question the credibility of that. You can challenge or question the accuracy of the information as it's being perceived by the person now giving the testimony, the memory the person has to be able to properly recall it, and motivation a person might have to lie, to make something up, bias, things like that, that challenges the value of that testimony. In a case like Jane Doe, you really don't have any cross-examination because, she is recalling something right out of, some of these horror movies.
Right.
Silence of the Lambs, essentially. And there's no cross-examination that you can possibly do. Now, again, I understand exactly why the defense attorney sat quietly, but there was a point during her testimony where the prosecutor asked a completely inappropriate and unnecessary question, and I wrote it down. Did you ever think you would leave the home? ? It's not relevant what she's thinking. It's speculative.
Let's get into that a little bit, because we do know, he kept her in this home where there were 2 other bodies found in this home. And like you said, it does sound kind of like a Hannibal Lecter kind of situation, a Silence of the Lambs incident, not trying to bring light to this dark situation. Yeah. However, why do you think that that's an inappropriate question? Because it's her, I would argue as a prosecutor that it was her impression at the time, whether or not she thought she was going to survive this horrible incident. So as a defense attorney, why do you think that it's inappropriate or irrelevant?
Well, it's asking for speculation. Again, in the context of the overall testimony, the defense attorney did the exact thing that I would do, which is you don't ask any questions. You're going to sit there. This is one of those cases where you're not going to win this trial. What you're hoping for is, as a defense attorney, people have the right to a trial. And if your client wants to go to trial, you take it to trial. This is one of these cases, though, where the evidence is overwhelming.
Yeah.
If this was a football game, the score is 100-0.
Yeah.
So you're hoping that there'll be some appealable issues, that maybe the judge made some mistake during the course of the trial that precluded the defendant from getting a fair trial, which then would be a successful appeal, reversed, and then a new trial. But the evidence here is so powerful and so overwhelming, I can't imagine a mistake being made by a judge that would rise to a level sufficient that it denied the defendant a fair trial.
Right.
That being said, that's why you take some of these horrific cases to trial. Why did the prosecutor ask that question? Exactly what he's doing. He's trying to create in the minds of the jury exactly this concept, and the jury the prosecutor wants the jury to perceive this case from the optics of Silence of the Lambs, and to look at this defendant, and the guilt is so absolutely obvious and apparent that there's no question as to what the ultimate verdict is going to be. Okay.
Well, I mean, you said it yourself. I mean, the evidence in this case is really overwhelming. We do have the 911 tape from Jane Doe, which we're going to play in a couple minutes. But before we get to that, because that 911 tape in itself is very eerie to listen to. Just listening to her voice during that period of time. But I just kind of want to press you on this just a little bit. As a criminal defense attorney, does your approach in cross-examining of an alleged victim, does that change based upon whether or not the victim is or the alleged victim, is providing what you deem as accurate information? Will that change your tactic during your cross-examination?
Absolutely, absolutely. So what happens prior to trial is you get the witness statements the statements are made to the police, and you have an opportunity to review those statements very carefully. And for someone like myself, I actually put every single statement that a witness has made to the police, or any recorded statements, or anything that I can possibly grab hold of that a witness has said, I put it to memory. I memorize it verbatim. So when that witness gets on the stand and starts testifying, I'm listening for changes and contradictions. Now, not every change, not every word said is going to be, identical to what they said before. But if they start going in a different direction, trying to help the case along, maybe add more information, then that gives me an opportunity to cross-examine the witness and then challenge the credibility of what they're saying. In a case like this, the way she's testifying, the voice, the fear, just rehashing what she experienced, there is no cross-examination. It doesn't matter. She could testify that, in the midst of all this thing, fairies came down and told her that, hang in there, you'll survive, you'll make this. She could testify about just about anything. It's not going to change the emotion and the sincerity and the honesty that she is conveying in her testimony before the jury. It is truly heart-wrenching.
It is, absolutely. Well, so what we're going to do right now for our viewers is we're going to actually play the 911 recording of when Jane Doe actually was able to make contact with 911 dispatch.
911, what is the address to your emergency?
4th Street, Laundromat.
What's the problem?
I've been abducted.
Who abducted you?
Shawn Grate.
Where's she at now?
Asleep.
Where's she sleeping at?
In the bedroom. Please hurry.
Does he have a weapon?
He's got a taser.
Are you tied up now?
Yeah, but I kind of freed myself. Are they on the way?
Yeah, we have officers we're sending.
Please send him up.
Hey, if you're worried you don't have to talk, you can just set the phone down, okay? I just need to hear if the officers find you or not.
Oh, shit. I woke him up.
Hey, just set the phone down. Okay, can you get to the door where you can see out? Huh? Can you get out of the house?
Locked.
It's locked. Are you at the door?
Yeah, I am.
She's at the door.
Come on out. Hurry up. Get out here. Where is he?
Bedroom sleeping.
Still sleeping?
Yeah.
Okay, they have her.
He's unarmed.
He's unarmed?
Yeah.
All right.
Welcome back. And you just heard that harrowing 911 recording from Jane Doe. And, you know, just to put all of this into perspective, Gary, we do know that when she's making this phone call, she's actually naked. And I just want our viewers to know that we do have court is back in session from their afternoon break, and we'll be sure to bring you back in live once we do know that they're continuing with testimony. But just to put everything into perspective, while she was on the phone, she still had not been dressed at that time. You know, she was standing by the door waiting for police officers to arrive, and she was naked. I mean, this is just such a horrible experience. What she experienced prior to being able to be let out by the 911 officers, the police officers, excuse me, who came to Shawn Grate's home. So, Gary, I think that you made an excellent point in saying that there really wouldn't be much of a great decision here in cross-examining. But what we do know is that the defense did decide to cross-examine her. And so what we're going to do is we're going to go back into the courtroom a little bit, but we're going to go back into the courtroom, but when we get back, we'll play that cross-examination for our viewers. We are still hearing some of the interview from Detective Kim Majors with defendant Shawn Michael Grate. We're going to still continue our conversation with Gary because he's just been providing us with so much great legal analysis. Gary, when we were off air, you and I were discussing a little bit about how efficient both the 911 dispatch and the police officers in this case were. Talk to us about that, Gary.
So she has no question in her mind that if Grate realizes that, you know, she's grabbed a cell phone and she's trying to get rescued, she's going to be dead. As soon as he wakes up and sees the cell phone near her, she's dead. So when she makes that 911 call, she knows if he wakes up and the police aren't there, she's dead. The police have no idea. They get a lot of weird calls. The 911 operators to be truly commended, because the 911 operator never questioned the credibility of the statement, took it as absolute truth.
Right.
And the police, this call is less than a minute, maybe less than a minute and a half long. And within that time frame, the police are in the house. They managed to get entry in the house, and they managed to save her before Grate wakes up. She says, I think he's awake. He's still sleeping in bed. I'm not sure. And you made a good point about the fact that she doesn't have any clothes on. Let me tell you, modesty is the last thing on her mind. She's thinking she is seconds from death. Okay? Mm-hmm. She probably didn't even notice she didn't have any clothes on. She could care less. She would grab those officers stark naked and hold on to them because they are the life raft that is going to save her life. Okay? These police officers, you know, if you've ever thought about a white knight in, you know, the knight in shining white armor coming and saving you, this is it. Those police officers are absolutely her saviors. That 911 operator is truly her savior. Right. And the fact that it, as well as it did, is truly amazing.
Right, and it just goes to show how, important their actual communication is, because we do know that when we were listening to the tape, it was Jane Doe who was speaking to the 911 operator, who was then delivering news to the police officers who were outside to let them know that Jane Doe was actually by the door waiting for them, waiting for them to be there so that she could leave. You also brought up another great point, the fact that, if he had woken up, God forbid, we don't know what would have happened, but we can assume the worst, right? We can absolutely. Yeah, we can assume the worst would happen, unfortunately. But, we do know that he did wake up. She actually thought that she did wake him up during a period of time. And, she had to be quiet. And we remember hearing from the 911 operator, she said, just put the phone down. And so, I thought that there was some great exercise of judgment. There was some great judgment on behalf of the 911 operator. And they just did a phenomenal job. So we just want to give kudos over to the Ashland County Police Department, as well as the 911 dispatch and operators over there.
Absolutely. I would use one word to describe the entire process of her rescue, and the word is flawless. Mm-hmm. Absolutely flawless.
Absolutely. What we're going to do now, as we promised our viewers, is we're going to actually show some of the cross-examination from the defense of Jane Doe. This is something Gary and I talked about. We didn't really think that it would have been proper for the defense to actually cross-examine Jane Doe in this case, but they did. We're pulling away from the clip that we are showing in regards to the cross-examination of Jane Doe in the Ohio versus Shawn Michael Grate case. We still have Gary with us. Gary, I do want to talk about this cross-examination here with you a little bit, because I was noticing that it seemed that they kind of got into the defendant's, or they were toting a fine line, I would say, in regards to the defendant's character, because the defense attorney talked about his demeanor. Let's explain to our viewers why that's kind of a slippery slope that the defense may not want to get into.
Well, he's a serial killer. He's abducted her. He's holding her against her will.
Right.
He's a bad man. And trying to get into her character, look, she may have her own personal issues and problems. The fact that she was a target, typically these people are not, victims are sought after by predators who are looking for weaknesses that they can take advantage of. Mm-hmm. Getting into exploiting, or now you're a defense attorney, and now you're trying to make hay out of these weaknesses that your client, your defendant, was able to identify and make this person into a victim. That's the slippery slope. What you're doing essentially is you're re-victimizing the victim. That leads to a backfiring. The idea is you're trying to show, hey, this person might be making something up. This person has a credibility issue. There's no credibility issue in this case. And when you tear into a witness, or you start to raise issues about their character, after particularly a heart-wrenching story, what you're doing essentially, particularly now with the Me Too movement and the idea that, blaming the victim has got to stop. That's the whole point of the Me Too, that, victims are victims, and they're vulnerable people and need to be treated with respect and with dignity. And that's why this cross-examination is a really tough cross to do.
I have to agree with you. We do know also, I took some notes while I was listening to this cross-examination. The defense attorney representing Shawn Michael Grate also stated that he seemed to have a calm demeanor, that he was respectful, that, he abided by her requests to stay outside of the home. But we do hear Jane Doe state as well that he would kind of try to sort of test the boundaries by seeing how far, her limits were, if he could actually put his foot across her threshold. So I do think that,
he's a classy abductor. Is that the point? I don't know.
Exactly. But that's the point that I wanted to make. I just don't understand the point that the defense attorney here was trying to make. I mean, we do know that at the end of the day, it's being alleged that he abducted her. The police obtained her from his home. The fact that she went to his home on 2 occasions, whether it was daylight or in the evening does not disrupt from the fact that, you know, Jane Doe was essentially pulled naked from his home. Am I correct?
Okay, there is this one play that you could possibly make. And
Okay,
again,
break it down for us.
You're looking for unicorns. Here it is. Okay, we play this sex game, and it's okay because it's agreeable. You know, he ties me up, and it's part of this role modeling that we do. It's role play. This is not a crime. This is, and the big word, it's consensual.
Right.
And then you show, well, she's been in the house before. There's been prior times where she's been here, and hey, she's not complaining about those events, so why is she complaining now? I mean, the whole point of it is, again, there is a concept that is recognized used by predators, and it's called grooming. And the whole idea is that, you know, abduction can be by a slow process. It doesn't necessarily mean that you grabbing somebody from the mall, and we've had a case like that, where someone's grabbed from the mall and taken and abducted and sexually assaulted and then murdered. That's your typical type of case.
Right.
You can also have degrees of abduction, but the bottom line is it's not consensual. And I don't think the defense attorney is going to be able to make any inroads in the issue about whether this is consensual or not. Clearly it isn't. And he's not going to be able to show that this was not an abduction. Again, vulnerable people that are targeted and become victims in these kinds of cases are the kind of people that are sought out specifically by these types of predators. And so it's not a surprise that she kind of walked into, this web that was created, and now trying to cross her on that and challenge her own lack of common sense, if you will, is not going to move the ball forward for the defense, in my view.
Great point. Great point. So we're going to continue on with this cross-examination from where we left off, and then we'll bring Gary back on so we can break it down for you all. Welcome back. You just watched the entire cross of Jane Doe by the defense attorney in the Shawn Michael Grate case. I know that you previously saw, we are still live. They are still in session in the court. However, if you could see previously, they are reading transcripts because of the fact that it is a little difficult to listen to the audio recording of the interview. And so, as you see right now, they are reading. They are actually reading through the transcript. And I can only assume that's in order to be able to correctly discern exactly what's being said during the interview with Detective Majors. So we're going to continue forward with our conversation with Gary. Gary, I know earlier that we were discussing, certain tactical approaches when cross-examining an alleged victim, but I do want to talk to you a little bit about this defense attorney's particular approach, because from my point of view, he sounds, and I don't know if that's exactly what he's trying to do, but he sounds a little accusatory on behalf of the victim when he's speaking to her, when he's speaking with Jane Doe. For example, he says, but you went with him freely, voluntarily, or he says you had a fight with him. That just seems more so of an accusatory tone, or the manner in which his statements were constructed just seems more of accusatory towards the victim than maybe a stand back approach. I don't know if that's the way that you took it.
Well, okay, so he did a couple different, I counted 4 different things that he did, and I can only say that they were all very disjointed.
Right.
So the first thing he did is what we call rapport building, and that's where you have a witness on the stand and you want to question them. So you're trying to now develop some kind of connection between the witness and you that you can then talk to them, and generally that's a friendly banter. So initially we had rapport building, and there's some friendly bantering, kind of a folksy approach. He's not a folksy guy. He's not. I mean, you can be creepy and be an excellent at cross-examination. In fact, some of the best attorneys in criminal defense are creepy people, right. And they creep out the person they're questioning, and it scares them. And sometimes they will say things you wouldn't expect them to say. So being creepy by itself is not a bad thing as a defense attorney, but you have to know, hey, I'm kind of creepy. I need to keep that in. That's sort of how I am. That's how I present. And in my view, he kind of presents as a little creepy. So the rapport building to me looked awkward. The next thing he does is, you're right, he starts with this sort of accusatory thing, and it doesn't seem to go anywhere. She's agreeing with him. He's using some words she doesn't understand. She's got a very simple vocabulary. He's trying to use conclusions to get her to agree with what he's arguing, but she can't follow the math. And so she's then questioning him like, well, what do you mean by that? Or what does that mean? And then she's adding more detail, which is not helping the cross, because the honesty of what she is testifying to just comes through more when she's being cross-examined. She's not trying to hide anything. In fact, she's trying to be accurate as she's being cross-examined. That's not good when you're trying to drill into a witness and show some deception. In fact, again, we use the word backfire. That's a backfire. And then we get into this other issue where he's now trying to establish that what we might call incompetence on the part of his client, not criminally responsible.
Right.
Hey, there's some sort of a mental illness going on here, and that he thinks that God is telling him to do things. I want to touch on that in a moment.
Absolutely.
Okay. So one of the arguments you can have when you have a case where you're dead in the water, then you say, well, he's crazy. Okay, why would a person do this? They're crazy, and so they're not guilty because they're crazy, not guilty because of insanity. A lovely defense. What does that mean? Well, it's not a walk in the park. NCR, not criminally responsible, is a very, very, very high burden. You can be one crazy son of a gun and still not be crazy enough to be able to get off on an insanity plea.
Right.
What do you have
can
to
you
show?
explain for our viewers exactly what the defense would have to show, and even from your jurisdiction, it doesn't necessarily have to be from Ohio, what the defense would have to generally show in order to show that the defendant was criminally or was insane at the time that the act was committed. I know a lot of the times they're unable to discern whether the acts that they were committed were right or wrong at the time. So if you would explain that for our viewers a little.
So in broad brush, so I'm going to give what they call the black letter law, which means basically this is sort of the uniform explanation of what insanity has to be for all 50 states, and then each state has their own little nuance to it. So I'm going to give you sort of the broad brush, but this would apply in Ohio, for example. So there's two arguments you can make that shows a person's crazy. One is that they are not able to understand or comprehend the nature of their conduct. So, and examples, I didn't know that was a gun I was holding in my hand. I thought it was a banana. That's a good example. That kind of crazy, okay? Mm-hmm. That kind of crazy is very hard to make. I've had two clients that fit that mold. I had one client who was on his way to give a letter to the president. It was President Obama at the time. He had a letter, and he was going to walk to see the president. On his way, he saw a child, and he thought she could use a hug, and he thought he was giving her a hug. He had no idea that he was kidnapping her, abducting her, taking her from the house. He was playing in the front yard, scared the heck out of her parents. He unfortunately was NCR, not criminally responsible. That's the first prong, or the first test of, there's two options you have, option one, option two. Firstly, you don't understand what you're doing. You can't comprehend the nature of your conduct. Again, think of it like this, very simple. I thought that was a banana that I was holding in my hand. I didn't know it was a handgun. That's how high that burden is. And there's a second one, and that's the one I think this defense attorney maybe was milling around with. And what that one is, I'm operating from a compulsion that I cannot control. That's where God is telling me to do something, and I can't disobey God. Okay, I'm hearing a voice in my head telling me, and I can't resist the compulsion. Okay, and he's kind of saying, well, was there any reference to God, and is there sort of a biblical reference? I think where he's trying to go with that is the second prong, which is my client maybe did this in part because he was acting from a compulsion. But again, weird to be doing that now. NCR is something you have to raise in your case. You need experts. It's actually two trials. The first trial is guilt or innocence, and then the second trial is whether you're crazy or not crazy.
Which is what we would call a bifurcated trial, correct?
Exactly, exactly. And to be doing it with this witness and doing it this way, it seemed a bit awkward, and it didn't go anywhere, and he shut it down after a while.
Exactly. I would have to agree with you. It seemed, and you broke it down. I love the steps that you gave. First, the rapport building. Second, the accusatory statements. And third, that he was trying to establish incompetence. You actually broke it down for us in a way that seemed to make sense, but actually in viewing the cross-examination, it seemed a little disjointed. I don't know if you would agree with me.
Very much so. Very disjointed. And not fluid. And again, know who you are, okay?
Right.
You know, for my own self, when I cross-examine a witness, which is my favorite part of a trial, I love cross-examination. That's my favorite thing. I'm not warm and friendly. I know who I am. I know how I approach a witness. I don't do report building. It doesn't work. I don't go there, okay? I go right for the kill. I'm looking for a cavity. I'm like a dentist. I've got a little scalpel, and I'm a prick, you know, the thing that you use, and I'm checking those teeth, looking for that nerve. And then when I find it, that hurts, good, okay. And now I want the jury to know that hurt, good. Now, I'm going to come back to that. You know I'm going to come back to that. Now I'm going to go into some other areas, but I'm going to come back to that again.
Right.
And what you want to do now is you want the witness, the way I do it, you want your witness to be scared of what you do, because you're tearing into that witness's credibility.
Right.
And you want the jury to know that.
Because essentially that's all that they have while they're on the stand is their credibility, because the jurors are the ones that are going to weigh whether or not they find this individual truthful or not, correct?
Right. And again, there's different things you can attack with a witness in cross-examination. Obviously, they're lying. Well, that's awesome if you can do that. But sometimes it's just perception. For example, My Cousin Vinny, great movie. If you take away all the humor from the movie, and you watch it as an attorney would watch it, and take away all the great acting and all that, what Vinny did was he was able to show that the witness's testimony was not accurate. Not that they were liars, but their ability to perceive and their ability to recall what happened is inaccurate, okay? And that's effective cross-examination, and he did it in a folksy kind of funny way, but when you take all the humor out of it,
Right.
what he's able to do is challenge their credibility based on their accuracy and their ability to perceive what happened. Different than accusing them of lying, because he didn't do that with any of those witnesses.
And that's what we call effective cross-examination. What we're going to do now is we're going to actually continue on with some clips that we had from earlier. The next clips that we're going to play will be the police interview between Shawn Michael Grate and Captain David Lay. So we're going to take a look at those clips, and then we'll be back to discuss them with Gary a little bit. We're sending you back into the courtroom live as they're playing a video of Shawn Michael Grate during his custody. Well, there you have it. We saw a video of, it was really kind of eerie video, watching Shawn Michael Grate demonstrate exactly how he choked his victims to Detective Kim Majors. I know that if you were able to see that and hear that video being played in the courtroom, and I know that it probably sent chills through some of your spines, because I know that it did to me. He seemed to do this without, and I'm going to bring in Gary to provide some commentary as well. Gary, he seemed to do this pretty much without, just from looking at his demeanor during the video, without any remorse. I mean, I think at a certain point I saw a smile on his face. It was just, he just explained it just so matter-of-factly, like it's something that he did all the time, which, you know, we can say that he did.
So, in my view, I think that, again, this is not a knock on Detective Major, but it may be in some ways an objective criticism. So police officers are trained on how to interview witnesses, and particularly how to interview a defendant. We call it custodial interrogation.
Right.
And part of that's what we call the Reed technique. This is sociologists have come up with ways and theories of how to question a potential target to get the most information that you can. And it breaks down to about 4 different ways. There's little bits and pieces of these 4. So, I'm talking broad brush strokes. And then you can say, well, you can little this and a little of that. And you do that when you do an interview. But let's talk about what the 4 are, because they're kind of important to understand. The first is, if you talk to me and tell me what happened, you'll feel better. So it'll be a catharsis, okay? And this is important. You'll feel better, okay? In his case, and that's what, and it's a criticism, because in the case of Mr. Grate, no, you're not going to feel better, okay? And I think that, and that seemed to be the approach that this detective was using, is that you'll feel better. Because he would feel better to talk about it if he did it. You got to take yourself, your own views and values, you throw that out, because that doesn't apply. You're living in his world. You got to look at the world through his optics, okay? So the feel better approach, it's a good technique, but you got to know who your target is. And in this case, it's a poorly applied technique. The second one is, this is your opportunity, okay? Let's make a deal. And that's plagued with all kinds of problems from a police officer standpoint. A lot of confessions have been thrown out on this is your opportunity. Like, I'll talk to the prosecutor. Hey, I can do something to help you out. You help me, I'll help you. Any of those kinds of things can actually throw out a confession, because the confession has to be voluntary.
Right.
And it maybe isn't voluntary anymore when it's let's make a deal. And so those kinds of that approach with the READ technique, using opportunity, this is your opportunity. It's awesome. You got to be very careful that you don't go too far, because you could blow your confession right out of the water. Your third is, and this is the one that I think that should have been applied, is pride. Pride. Dude, you are amazing. How did you do it? How did you manage to do it for so long? If Majors had used that approach with this guy, you wouldn't get him to shut up. That's the approach this guy needs. You need to say, take pride in what you do. And then the fourth one is, I want to understand why you did what you did.
Okay.
I don't need the facts.
Absolutely.
You don't need to confess. I just want to understand. And of course, the understanding is really, I want to get the facts. But
Absolutely.
a lot of people just want to have someone listen to them.
Yeah.
So if you say, I want to understand, they won't shut up.
Yeah, they won't. I thought those were great points to make. And I think the pride approach would have been the perfect approach in dealing with Shawn Michael Grate. But unfortunately, we're going to have to cut to a commercial break. But when we come back, we'll hopefully still have Gary with us for a few more minutes, because, we're going to have some great breakdown for you. Welcome back to Law and Crime Live. My name is Stephanie L. Willis, and I am still here with you this afternoon, where I believe we may have some great coverage for you. We are looking to get into some coverage over the Golden State Killer. As some of you may know, James Joseph D'Angelo, who's 72 years old, was taken into custody on Tuesday outside of his home in Citrus Heights, which is 20 miles northwest of Sacramento, approximately 6 days after he spent 6 days under police surveillance. Mr. D'Angelo is an ex-cop who's accused of a series of rapes and murders attributed to the Golden State Killer over 4 decades, and he's scheduled to appear in court today in Sacramento as his first public appearance since police tracked him down using DNA samples and a genealogical website. That's right, a website that's kind of similar to, we don't know exactly which website it is. Let me state that. I just want to make sure I'm stating that, but it's something that's similar to Ancestry.com or 23andMe. And so what happened was this was a process that began by using DNA from one of the crime scenes from years ago, and then they compared it to genetic profiles that were available online through various websites that cater to individuals who want to know more about their familial backgrounds by accepting DNA samples. So that's exactly how they came to find James Joseph D'Angelo as the Golden State Killer, or as some of you may know as the East, excuse me. We're also getting some more coverage into this. He's connected into over 12 murders, over 45 rapes, and over 100 home invasion burglaries throughout the 1970s and 1980s. As I was stating before, he is also known as the East Area Rapist, or the original Night Stalker. So we know that what would happen is he would break into the homes of primarily married couples, and he would essentially break into the homes, sometimes rape the wife, tie up both the husband and the wife, and in some cases would kill the couples. So, this is I guess a situation that has been long going for a while, and a lot of people are up in arms as to the fact that they actually caught this individual by the name of Joseph James D'Angelo after years. This is years of searching, ladies and gentlemen. Since the 1970s and 80s, they've been looking for this individual who is connected to these home invasions, these rapes, and these murders. And so Sacramento Police Department believe that they may have found the individual who they are alleging him to be Joseph James D'Angelo. As we know, Joseph James D'Angelo is 72 years old right now, and he was taken into custody on Tuesday night. Gary, do we still have Gary with us this afternoon? Okay, we're going to bring in Gary with us just to talk a little bit about this because I do find it interesting how they were able to connect Mr. D'Angelo to this to these alleged not the alleged incidents, to these incidents. It's been for a while. Individuals have discussed, I guess, maybe a problem. We don't really want to call it a problem, or maybe an issue with submitting DNA samples, to genealogical websites such as Ancestry.com and 23andMe, because then it makes your DNA profile available to individuals in the police department. So let's talk about that a little bit.
Well, it is absolutely a fascinating case, and it does raise some interesting issues.
I know that we're maybe having some sound problems from Gary at this point. I'm trying to check in with our control room to see if we still have him with us. Okay.
1, 2, 3.
Can we just make sure that Gary is still able to be? Okay, Gary, can you start over for us? Just a little. We had a little technical difficulty, and I know that you were raring to go. So if you would just start over from scratch for us and explain this for us and how important these DNA profiles are.
I'll take a shot at it. So
Thanks.
My office has been following this case very closely because it's a big area that we take an interest in, which is okay. So here's the issue. We have what's the Fourth Amendment, which it talks about unreasonable search and seizure. So law enforcement, they want to solve crime, and the easiest way to solve crime would be to know everything about everybody, and that way, if a crime occurs, you're able to identify who did it, and it makes the job a lot easier. One of the greatest, most unique, and considered the gold standard in terms of identifying a who is DNA. It is the gold standard of evidence. Beats fingerprints, it beats everything. DNA, the gold standard, no question about it. The problem is that the police have been hampered through many, many very important cases that have gone all the way up to the Supreme Court, that your DNA is kind of private, and the police can't just come and take your DNA. They can. And that creates a whole kind of issue about taking people's DNA, getting a swab of someone's inside of their mouth, for example, and getting those cells, and then being able to identify, that's the who, or at least that's you, and now we can then attach that to this crime solved. So in this case, what happened is Mr. D'Angelo, he sort of made it easy for them. He went to a website and said, here, I kind of want to know a little bit about myself. I want to know where I come from. And well, there's no privacy because when you sign that, well, when you send stuff off to the internet, those terms that, terms and conditions apply, please check mark, no one ever reads it. Well, he didn't read it. And apparently this information now is available to anybody. Law enforcement got lucky. They were like, oh man, I wonder if maybe we went to one of these providers that does this DNA testing, maybe because we had DNA, they had DNA,
right.
But they don't. It came back negative. No, they couldn't find a suspect. They had no question if they, if they could find out who this DNA belongs to, they got a good handle on who committed this crime, and they just didn't have that person. And they go to a website, and boom, they get lucky. And now Mr. D'Angelo, who had no idea that he was ever going to be a target. This guy's 72 years old. He's retired. He's living a quiet life now. His murdering, raping, and killing days are behind him. And now he's looking at his DNA profile. He's living the life. And suddenly, out of nowhere, the long arm of the law, boom, gets him. Great case.
Yep. Well, we're getting, my producers are letting me know that unfortunately the hearing already occurred. What we do know is that they, part of the reason why they were able to obtain his DNA is because they picked up on DNA from a relative. So I want to discuss that a little bit, because they weren't able to obtain his DNA, or they weren't able to figure out that it was someone, I guess, in his familial lineage, I would say, until they picked up on his relative's DNA, and then they found his DNA. So this is sort of a compounded question, or maybe a little confusing question that I'm asking, but I foresee some challenges or some issues in the courtroom, or at least I would present some challenges as a criminal defense attorney in regards to the way that they actually obtained this DNA sample. What do you think about that?
Well, I mean, the technical issues are interesting, and that is, guilt by association, which is kind of funny when you think about it, but truly it is guilt by association. They gather DNA from a relative, and they're able to connect that relative to Mr. D'Angelo by the fact that the DNA profiles are similar. And that similarity, or the issue of that similarity, will be a focus point in his defense and ultimately in the prosecution. Well, in first brush, in the prosecution's case, is to show that, the connecting those dots. And that's a technical aspect, and that's going to be fascinating to watch as this trial unfolds. But still, what's really interesting is how they managed to put it together. And that was, they took a shot and they just went hunting for DNA sort of through the internet. Very interesting.
Absolutely, absolutely. And so we're also getting some updates from our producers that the next hearing will be set for May the 14th, and that he did not enter a plea today. So we will continue to provide updates for our viewers. And I know, Gary, you're going to stay tuned to this case, because I know that it has the potential to affect a lot of your clients in the future, because if someone does submit their DNA profile to find out their familial lineage, then they're essentially exposed to a lot more than they may have bargained for, correct?
Absolutely, absolutely. This case takes the TV show Dexter to a whole new level, no question about it.
Absolutely. Well, we'll see where this case takes us. We do know that, and I do believe that Mr. D'Angelo was brought in a wheelchair. I'm trying to provide a description to our viewers. We do know that he is 72 years old, so he's he's on the older end of the spectrum. He was wearing an orange suit. I believe he was brought in via a wheelchair. This, I guess, it can make quite a visual aspect for our viewers today, and we'll be sure to provide all of our viewers, with the latest updates as soon as we receive them. But we do want to thank Gary. Thank you so much for being with us this afternoon. You really provided some great legal breakdowns for us in the Shawn Michael Grate case, as well as this case with Mr. D'Angelo that we have here, the Golden State Killer. So we want to thank you so much for being with us this afternoon, and we welcome you back here on Law and Crime Live whenever we can have you back again.
Thank you, Stephanie. It was fun.
Absolutely. And so we're going to continue on. We're going to be here for a little bit longer this afternoon, not that much longer. Only the day is quite winding down. But just to reiterate, for our viewers who may have missed it, we do know that there was some kind of a hearing today in the Golden State Killer matter. We do know that Mr. D'Angelo did not officially enter a plea, and we do know that he will have his next hearing date on May the 14th. If our viewers are not familiar, the Golden State Killer was someone who law enforcement had been looking for years. These crimes were committed back in the 1970s and the 80s that ranged from murders, rapes, burglaries, and home invasions. And so this is a real breakthrough in that case, in which they were able to charge Mr. D'Angelo here with these crimes. And I'm sure that there are a lot of people who have a sense of relief, even though he is 72 years old at this time. So we will be sure to provide you with updates. We will also be sure to continue with providing you with coverage in the Ohio versus Shawn Michael Grate case, which will resume on Monday, so be sure to stay tuned to that, and we'll be providing you with great coverage with that. So stay tuned, ladies and gentlemen. We hope that you have a wonderful weekend, and we look forward to seeing you back with us again on Monday. Thank you so much. Stephanie L. Willis signing off.